Hello, this is Professor Keith Ross from the John Jay College of Criminal Justice with a continuing set of lectures for my Introduction to Criminal Justice course. We are on Chapter 9, and we're going to be talking about sentencing. So really, what we're doing now is we're transitioning from the courts solely into the last part of the criminal justice system, which is that correctional system. So when we're talking about sentencing, all of that other stuff that we've talked about during that 12-step criminal justice process has taken place. We're at the trial. There were the opening arguments. We had the prosecutor with his or her direct, defense attorney with his or her cross, and then the redirect, the recross, closing arguments. Jury gets sequestered, and they do what? They deliberate. What are they deliberating on? Whether the strength or the merits of the case merit a person to be found guilty beyond a reasonable doubt. Once this jury has decided, or it could be a judge as well, but once this jury has decided that a person is guilty beyond a reasonable doubt, well, now it's solely up to the judge to confer some type of sentencing. And why would a judge sentence somebody? Well, as James Q. Wilson says, wicked people exist in this society. And what do we want to do? Well, we want to try and get them out of society, not by death, but we want to sentence them to some type of incarceration so that they can't do this anymore. Now, one of the main topics in this chapter is slide number 4, which is the goals of sentencing. The goals of sentencing, you can also read it as sort of the goals of the correctional system. So there are many reasons for imposing these sanctions. Some might be contradictory, and none of them operate by themselves. So their goals, these goals can overlap mutually. So nothing exists in a vacuum. So we have retribution, deterrence, incapacitation, rehabilitation, and this idea of proportionality. What is retribution? Well, retribution reflects society's moral outrage or disapproval of a crime. We focus really on the crime and not the individual. This focus is to punish, not really deterring future criminality. This person has committed an offense, and we want to punish them because we want to show that when you commit this offense, there are consequences, in some cases, dire consequences. The sentence should be proportionate to the crime. And why is this? Well, because the Eighth Amendment prohibits excessive bail and or punishment. The offender receives their just rewards, their just deserts, meaning that if you commit an offense, and usually what we're talking about, we're not really talking too much about those misdemeanor or lesser violent offenses. We're really talking about felonies and some of those major felonies that seem to be such an offense to the moral fabric of society that we want to punish, we want to incarcerate, we want to send a message that if you do the crime, you're going to do the time. So we have this. Now, we have retribution. The next one, deterrence. People are rational beings with free will who will normally pick pleasure over pain. People weigh the benefits and costs of future actions before deciding to act. Excuse me. So we have this idea of retribution, and sort of incorporated in retribution is this other concept of deterrence. Big takeaway from this, there are really two types of deterrences that are discussed in the book. There is specific and there is general deterrence. Really just an easy way to think about this is that specific deterrence is specific to the individual, that we wanted to deter this individual from future acts of criminality. General deterrence means it's aimed at anyone who might be considering committing this offense. Incapacitation, removal of offenders from the community through imprisonment or banishment. We don't really use that term banishment anymore. That's sort of an archaic term. But this is really sort of an easy concept, that if someone commits an offense against society, against statute, and they are found guilty, well, one of the reasons why we sentence them is because if they're sentenced and they're sentenced to some type of incarceration, while they are incarcerated, they cannot perpetrate this crime against society again. Has no bearing on if and when they get released from incarceration, but at the time that they are incarcerated, they cannot commit this offense. Really the big one, and for those of you that are keeping up with the news and the correctional system, this idea of rehabilitation. Now, one of the concepts that we've come back to over and over again in my class is that one of the purposes of the criminal justice system is to make people better. When an offense has been committed, something has been taken away. Well, what do we want to do? We want to try and make that person whole. Now, a lot of times when we've talked about this, we've talked about the criminal justice system and its goals towards victims. That a victim has been wronged, something has been taken away from them, so we want to try and repair that and make that person whole. But this sort of idea can also be extended to offenders, because we incarcerate someone, we imprison them. More often than not, unless they are sentenced to either a life term of imprisonment or they're sentenced to death, they're going to get out. And they have, quote unquote, paid their debt to society. And we want them to be productive members of society. So when we talk about this idea of rehabilitation, we talk about this idea of reforming the offender, making the offender better leaving the criminal justice system than when they entered the criminal justice system. So reforming an offender to become a productive member of society through treatment. One of the facts is that 1 in 5 people have some sort, could be slight, but some sort of mental illness. So if we're using that, 20% at the very least have some sort of mental illness of some kind. On top of that, we can talk about sociological factors, low socioeconomic backgrounds, poor educational skills, things to that nature. So we might want to treat those symptoms. Again, why? What are we trying to do? Well, we're trying to make this offender better when he or she leaves the criminal justice system as opposed to when they entered. Well, we want them to be a productive member of society. So what does that really mean? What are we talking about? Well, we want them to contribute. We want them to work. We want them to pay taxes. We want them to buy that house with the 2.3 children and the white picket fence and the trophy dog. Well, how are you going to do that? Well, you need to get a job. Well, there are a lot of jobs available, but the facts are that the more education you have, the better your earning capacity is, the better your earning potential is. So a lot of times we have people that enter into the criminal justice system, especially we're talking about the incarceration side of this, that maybe don't even have a high school diploma. Well, if you don't have a high school diploma, you can earn your high school diploma in jail, in prison. If you have a high school diploma, guess what? You can earn a bachelor's degree in jail, in prison. If you got a bachelor's degree, guess what? You can get a master's degree in jail and in prison. You could also get a Juris Doctorate, which is the degree necessary to practice law. And oddly enough, you'd be surprised, there have been many people that have been incarcerated that have gone on to become lawyers. More likely than not, they're probably criminal defense attorneys. And counseling. And counseling is sort of part and parcel with this idea of treatment. This was the dominant philosophy during the 1940s through the 1970s. There was sort of a change in the social sort of perception of crime, and we always go through these cycles where we either concentrate on the offender or we concentrate on society. I mean, really, when we're talking about sociology, I think one of the biggest issues confronted in any type of sociological pursuit or study is this idea of balancing the concerns of the individual versus the concerns of society, and how do we make these fit together. Identify causes of criminality, determine treatment, and like we want to determine treatment. Why? Because if this person has a better education, if this person had issues entering, and we treat those symptoms, we treat those illnesses, we've made them better. If we've made them better, the thought process here is that they will not be as likely to reoffend in the future. When we're talking about this, of course, there are always studies. We look to see, well, we've applied this. We've applied this sort of theory. We've applied this program. What kind of results are we getting? And studies show that rehabilitation works on some of the time for some of the offenders. So it does work, but we don't know what their success rate is. And it's not a success rate across the board. There are probably more moving parts than just looking at offender treatment. Are they better? There's probably more things going on there that really have to be considered. This theory is cyclical, and in the PowerPoint presentation, I wrote that it is starting to gain favor again. Especially for us that are in New York State, we're all about rehabilitating the offender. As a matter of fact, we are right now in this area of bail reform. And again, this is a program that's been implemented, and what we're going to have to do is we're going to have to study it, we're going to have to look at it, see what its short-term outcomes are and what are its long-term outcomes. Is it negatively or positively impacting the offender and society as a whole? Next concept, and the last concept, is this idea of proportionality. And when we're talking about proportionality, again, we're really back to the Constitution, and we're talking about the Eighth Amendment. That the Eighth Amendment prohibits government from giving out these excessive punishments. Fairness, making the punishment fit the crime. Now, depending on the offense that we talk about, there are some sort of like social mores that we just feel into it. When we talk about people that have been convicted of sexual assaults, maybe sexual assaults against children, there's this immediate emotional response. Well, let's get rid of them forever. Does that fit? And, this is not a question I'm going to answer. This is a question that you have to answer. This is a question that society has to answer. However, in modern day 21st century, we don't abide by the code of Hammurabi, an eye for an eye. So if you kill a person, you don't necessarily get put to death. And it depends on the social zeitgeist at the time. And really the issue facing society, facing judges, facing the criminal justice system is, well, what punishment does fit the crime? The ultimate determination of proportionality, again, if someone appeals a trial verdict, well, they go to an appellate court. If they don't find the relief that they were looking for in the appellate court, well, they can apply to the Supreme Court, which is, again, the highest court in the land. Let's talk about now intermediate sentences. Now, more often than not, when we're talking about intermediate sentences, what we're talking about people that have been convicted either of misdemeanors or what's termed to be nonviolent felonies. And usually when we're talking about non-violent felonies, those classifications tend to be like at least in New York State, classifications like D and E, where there probably were victims, but the victims weren't injured, or not injured in the way that we normally sort of think about. So an intermittent incarceration, a short sentence, or a staggered sentence, these are sort of like those weekend furloughs, where let's say a person has been sentenced to an offense, but they work, they have families. So, the criminal justice system will recognize this. Judges will recognize this. So if you just incarcerate that person, well, now that person can't work. If that person can't work, that person can't earn money. If that person can't earn money, what happens to the family? Now you've not only incarcerated the individual that committed the offense, but now there are consequences outside of that offender. There are consequences to his or her family. So maybe a judge might consider an intermediate incarceration, intense probation supervision. Don't get confused between probation and parole. Real sort of easy way, a real broad brushstroke to think about the difference between probation and parole. A person gets sentenced to probation. A person who is on parole has served some of their sentence incarcerated. So maybe instead of putting this person in a jail or a prison, they get sentenced to probation, means that they get assigned a probation officer, and that probation officer watches over this person. Does the person become gainfully employed? Does the person follow a curfew? Things of that nature. What kinds of activities are the probationee engaging in? Are they going to church? Are they going back to the old neighborhood and doing what it is that they did before? Maybe instead of incarceration, the person pays a fine. Usually this is like traffic infractions, but it could be something else. And more often than not, when we're talking about misdemeanors, instead of incarceration, well, what do we want to do? Well, we want them to pay their debt to society. Maybe one of the ways that they pay their debt to society is instead of housing them in incarceration, we ask them to perform community service. A lot of times, if you're driving on a highway, you'll see people cleaning up the highway. Well, what are they doing? More likely than not, they're performing a community service because they were sentenced, let's say, 240 hours by a judge. Restitution. You wronged a victim, and the criminal justice system has the concept is that we want to make that victim whole. Well, maybe one of the ways is that if you as an offender took something from that victim, well, now you're going to have to pay that debt back, and you're going to have to pay that debt back financially. Forfeiture. You gained assets by committing crime. Well, one of the provisions of your sentencing is that you lose those assets. A lot of times we'll read about people that are drug trafficking, dealing drugs. Well, let's say they made a lot of money, so they bought a real nice car, they bought a real nice house. Well, the government will actually seize that property and then auction it off. And that's what's called asset forfeiture. Indeterminate prison sentences. Now, be careful, because a lot of people use the terms jail and prison interchangeably, but you should know that that's not the case. When we're talking about jails, at least in New York State and most of the United States of America, I'd probably say all, but I'm not 100% sure on that. When we're talking about jails, what are we talking about? Well, we're talking about someone that has been convicted of a misdemeanor, and they will serve whatever sentence is imparted to them in a jail, in a city municipal jail or a county jail. In New York State, remember, the maximum sentence a person can receive, 1 year, whether it's 365 or 366 days. When we're talking about prisons, we're talking about felonies. Minimum sentence, 1 year plus 1 day. The maximum sentence could be anything, depending on if that punishment fits the crime. Indeterminate prison sentences establishes a minimum and a maximum number of years to be served. Let's say that a person commits a robbery, gets found guilty beyond a reasonable doubt. Maybe the judge sentences them a range, let's say anywhere from 3 to 8 years. I'm just picking out numbers. I'm not saying that these are the numbers. 3 to 8 years. So the minimum sentence is 3 years, the maximum sentence is 8 years, but the judge could determine something in between, 5 years. At least 1/3 of the minimum sentence must be served. So let's say again, robbery, you're sentenced to robbery, and the judge imposes the minimum sentence, 3 years. That person has to serve at least 1 full year in prison before we can revisit this. We can consider maybe parole or options like that. Determined or structured prison sentences are fixed sentences, that these must be imposed. This emerged as a result of the sentencing reform movement of the 70s because it was determined that rehabilitation wasn't working, that it was only working on some offenders some of the time. So what is the goal? Eliminating sentencing disparities. So what it does is that it sort of closes down the discretion that judges have. So, if a judge is more along the lines of a rehabilitation-focused judge, as opposed to someone that is more a retribution-focused judge, well, this sort of closes that gap between those two. So it eliminates sentencing disparities and reduces the discretion, again, of judges. And what it does is that it creates a uniform system of sentences across the board. Presumptive sentencing, a range of minimum and maximum terms. The judge will determine specific number of years served within that range. And that's really what we've been talking about, the robbery with the 3 to 8. Well, it's up to the judge to presume what the best sentencing will be. What is the sentencing that's going to be most fair both to the offender and to society? The judge may depart from presumptive sentencing if aggravating or mitigating factors exist. Aggravating factors. Well, is this person what's considered to be a quote-unquote predicate felon? Have they committed this same offense over and over and over again? Maybe mitigating circumstances is that this person commits these offenses, but they have issues at home, sick relatives, something like that. It could be a million different things. There are a million different variables that can weigh on a judge, whether he or she presumes to impart some type of sentence. Sentencing guidelines limits the judge's discretion and imposes disparate sentences for similar offenders, So a person that commits robbery, sentencing guidelines say minimum 3 to 8. So a judge couldn't say, well, you know what? I know you were sentenced to robbery, but this is your first time and I really like your face. I'm only going to give you a year and a day. Or on the other side of the coin, you've done this before and I don't really like your face. You're getting 20 years for this robbery. Well, judges can't do that. Judges can't do that, and that's why these guidelines have been implemented and imposed. Mandatory sentences requires imprisonment of offenders who are convicted of certain types of serious crimes. Now, when we're talking about serious crimes, a lot of factors can go into this, but really more often than not, when we're talking about those serious crimes, I've sort of given you that acronym, that Mr. Rab steals cars, where we're talking murder, manslaughter, rape, robbery, felonious assaults. So at least in New York State, we're only talking about assault, second degree, assault, first degree, burglaries, larcenies. We could probably also throw arsons in there. We could throw kidnappings in there. And when we talk about the concept that are of rape, really include a lot of different offenses in the sexual assault realm. So it's not just rape. At least in New York State, the Criminal Sex Act, Aggravated Sex Act, things of that nature. Habitual offender statute. So what we're talking about here are predicate felons, the person who does this over and over again. Why did we incarcerate them? Well, we wanted to show some retribution. We wanted to deter them from doing this in the future. However, incarceration seemed to have not worked. So the sentences start getting harsher and harsher. Now, that works for a lot of people, but there are some issues with this. And one of the issues, and I posted a YouTube link on the PowerPoint, I think you guys should actually watch it, talks about California's 3-strike laws. That if a person commits an offense 3 times, really strict, really harsh sentencing will take place. And if I remember correctly, in this video, the person, his 3rd strike was robbing a gas convenience store for a candy bar, and he was sentenced to 20 years for it. Something to that effect. Requires longer sentences for offenders convicted of their 3rd violent felony. Unintended consequences, a positive association with homicide rates, and here's the real main issue of what we're talking about today in today's society, this idea of bias in the criminal justice system, disproportionately harsh effects on African Americans. It is what it is. It's something to study. I don't really want to get into it in this class, because this class really is more just a primer of the criminal justice system, not really sort of sociological biases and impacts of the criminal justice system. Truth in sentencing requires offenders, and especially violent offenders. Now, when we're talking about violent felonies, again, obviously murder, manslaughter, the sexual assaults, robberies, felonious assaults, and at least semi-now, burglaries have been considered to be violent. There is a social zeitgeist that is starting to move away from that idea that a lot of times when we're talking about burglaries, and a lot of people get this concept wrong. What is a burglary? Well, a burglary is a criminal trespass where you enter a building without permission or authority, without license and privilege, with the intent to commit some other crime. More often than not, when we think of burglaries, what we're thinking about is we're thinking about a criminal trespass plus a larceny, the removal of property without permission or authority, without license or privilege. Doesn't have to be a larceny. It could be other effects. Someone could break into someone's house to kill a person. Let's say the person does do that. Well, it's definitely going to be the murder charge. They intentionally killed a person. The secondary charge would be burglary, because what did they do? They entered a building that they didn't have license and privilege in. Why? Because they had the intent to kill the person. The intent is shown by what? That they actually accomplished that objective. Establishes a closer correspondence between judicially imposed sentences and the actual time served in prison. So this truth in sentencing laws, if I'm, let's say, sentenced to 8 years, well, I'm going to have to do about 85% of that 8 years. I'm not exactly sure what the numbers are, how they work out. Sounds to me that it's probably about 6.5 to 7 years that I'm going to have to serve before I even have the consideration of being released. I am now on slide number 21, this idea of concurrent and consecutive sentencing. If we're talking about trials and sentencing, more often than not, we're not just talking about a singular charge. Usually there are multiple charges, and there could be multiple counts of similar charges. Let's say I break into someone's house with the intent to kill a person, and I kill 2 people. Well, there's a burglary, and I've also committed a murder, but how many murders have I committed? Well, I've committed 2 murders. I killed 2 people. Well, those are 2 counts, and I have to account. I have to be held responsible for each of those counts. Now, if I am found guilty beyond a reasonable doubt, the judge has the discretion to sentence me to an either concurrent or a consecutive sentence. So what are we talking about here? Concurrent sentences, a multiple sentence served at the same time. So let's say I'm convicted of those 2 murders, and I'm getting 20 years for each of those murders. I'm just picking out numbers. I'm not saying that these are the right or factual numbers. If the judge imposes a concurrent sentence on me, I will serve 20 years for both of those sentences, that I will serve each count concurrently. So I'm not doing it one after the other. I'm doing both counts at the same time. Consecutive sentences is sort of the exact opposite. Multiple sentences served one after the other. So in the crazy example that I just gave you, found guilty of 2 murders, I'm sentenced to 20 years for each of those murders, and the judge imposes a consecutive sentence. I'm going to serve 20 years for the first count. Once that has been up, I'm going to serve another 20 years for the second account. So in effect, I'm doing 40 years for those 2 counts. If we're talking concurrent, 20 years for the 2 counts. If we're talking consecutive, 40 years for the 2 counts. Well, we keep on talking about these sentencing ideas. Well, now we have to ask, well, how does a judge arrive at an appropriate sentence? And I am on slide number 23 now. Really important, the pre-sentence investigation report, sometimes called the PSI. Now, this is a whole bunch of information compiled by a whole lot of people that give the judge really sort of a well-rounded picture of this offender, widely believed to be the cornerstone of sentencing decisions. This is a comprehensive report of offender background, the offense committed, and other relevant information. Is the person gainfully employed? Does the person have an education? Does the person have substance abuse issues? Does the person have any sort of mental issues? Things of that nature. Helps the court understand the nature of the crime within the context of the offender's life. So what we're trying to figure out here is, why did the offender commit this? What caused the offender to commit this? Was this an evil person? Was this a person of low socioeconomic means? There are a lot of moving parts here. There are a lot of considerations that need to be taken into account, and that's sort of what this PSI does. Based on interviews with the offender, him or herself, the family members of the offender, employers, friends, police reports, probation reports, victim statements, can include sentence recommendations from probation officers, can include sentence recommendations from prosecutors, things of that nature. The sentencing hearing. Felony sentencing takes place at a sentencing hearing on or about 3 to 6 weeks after the verdict. Sort of a loose number. Could be more, could be less. A lot of mitigating factors. If there's a lot of media response, the media is probably going to sort of want to see this happen quicker, and the courts are going to want to make this quicker. The offender may deny, may explain concepts, or add information into his or her PSI report. And as I said before, the prosecutor can also make recommendations. The role of the victim in sentencing. Victims are permitted to submit what's called a VIS, or a victim impact statement, oral or written. Well, this is the victim being able to tell his or her story as to how they've been impacted by the actions of the offender. How the offender, this person was whole, and the offender took something away from this victim. Disparity and discrimination in sentencing. Well, what we're talking about here is really sort of a concept that's being evaluated all across the United States of America, this idea of bias in the criminal justice system. Determinant sentencing reduces sentencing disparity, but it does not eliminate it. Sentencing disparities can occur when similar cases are sentenced differently. Now, well, how does this happen? Well, it could be a racial bias, it could be a gender bias, but it could also be a socioeconomic bias. If I'm a person of low socioeconomic means and I cannot afford a lawyer will be appointed to me at no cost to me. Well, how many cases does that lawyer have? How much focus is that lawyer going to focus on my particular case? Not an easy question to answer, but let's say I'm a person of high socioeconomic means and I can afford that $500 to $750 an hour defense attorney. Well, do you think I'm going to be a priority for that defense attorney? I'm probably going to be more of a priority than the one that was appointed to me if I'm of low socioeconomic means. So that attorney will do everything in his or her power to get the most minimum sentence, if the person even gets sentenced. Sentencing discrimination exists when illegitimate, morally objectionable, or extra legal factors are taken into account in the sentencing decision. We just brought up a couple of things. We talked about this idea of race, that African Americans are disproportionately receiving stricter prison sentences than other ethnicities. Gender, and when we're talking about gender, really the book sort of gets that term wrong. I think maybe we should use the term sex, because the purveying zeitgeist right now is that there are a lot more different models of gender than just male and female. But when we're talking about the bias of sex, what we're talking about is that women find increasingly leniency at all stages of the system. So that a woman commits robbery, gets convicted and sentenced, and her male counterpart the same, more likely than not, the male will face a stricter or a harsher sentence than his female counterpart. Socioeconomic status. Well, if I can afford a better attorney, that better attorney is probably going to perform better for me. Age. The research is mixed, but recent study found no significant relationship between the offender's age and the length of sentence. So a person who's 60 years old as opposed to a person who's 30 years old committing robbery, there's really no statistical data to suggest that the 60-year-old will get a less harsh sentence. The last concept that we're going to talk about is this idea of capital punishment, being sentenced to death. Between 1930 and 2009, over 5,000 executions in the United States. The average was about 104 executions each year. I don't really have the figures now. My assumption would be across the board, if we're looking at the United States of America, capital punishment has been decreasing. The amount of executions has also been decreasing. When we're talking about the death penalty, 36 states, federal governments have statutes authorizing the death penalty. Interestingly enough, New York does have a death penalty. It has never been removed from the books. However, in the mid-2000s, it was found to be unconstitutional. So it's sort of this weird disconnect that we do have the death penalty, but it's been found unconstitutional to the state of New York, and it's never been challenged any further to the United States Supreme Court. So in New York State, no one gets sentenced to death. The harshest prison sentence that a person will receive will be life imprisonment. Since 1977, executions carried out in 34 states, with over 1/3 of them taking place in Texas. The majority of prisoners under sentence of death in 2009 were Caucasian, white, never married, had less than a high school education, and they were overwhelmingly male. Methods of execution used in the United States, well, we have lethal injection, electrocution, lethal gas, hanging, and firing squad. I cannot recall a time in my lifetime where hanging and firing squads have been used in the United States of America. Gas has been used, electrocution has been used, but probably the most preferred method, I don't mean the word prefer, but the method used most in the United States of America is this idea of lethal injection, because it seemed to be the most humane way to put a person to death. And I know there's sort of an oxymoronic thing going on there. Well, we're killing a person, but we want to do it humanely. Well, how do you kill a person humanely? Well, when we're talking about lethal injections, it's not just one injection that's, the death kill right there. Really what's going to happen is that the person's probably going to be put to sleep with some sort of pain relief injection. So they're not going to feel the next one or two injections, which will actually just stop the heart. Arguments for capital punishment. It's a deterrence. If a person knows that they can be put to death for an offense, maybe they will be deterred from committing that offense. Then also this idea of retribution or justification. There is a broad support for the death penalty in the United States, but that, again, really sort of depends state to state. The arguments against capital punishment, well, we're talking about this idea that lethal injection is humane. Well, is it really humane to kill a person? Is that what humanity is? Is that what we want our great society to be, that we kill people? So discrimination in application, it's a brutal effect on society, that how we're this great society, we're humane, we're better than this, but we're killing people. Criminal justice system also is not infallible. There have been times where a person has been found guilty beyond a reasonable doubt, and then evidence has come to light that has vindicated or exonerated that person, so that the person was not actually guilty. In the United States of America, there is a project called the Innocence Project, and that's really what their main focus is. And a lot of times what they're doing is they're using DNA forensic evidence to exonerate individuals that have been incarcerated. The last thing, we've really sort of talked about this in a couple of different lectures, is this idea of grounds for appellate review of sentence. Well, what are we looking at? We're looking at that the sentence violates the Eighth Amendment, that the sentence is cruel and unusual in terms of the offense that the person has committed and has been sentenced to, or that the sentence is disproportionate. It's too harsh for this person, that there was an abuse of discretionary power. When we're talking about this idea of abuse of discretionary power, we're either talking about the prosecution or we're talking about the judges. Fell outside statutory sentencing guidelines. As we said, that judges have a sentencing guideline that they should abide by. Sometimes judges, depending on the state, depending on the offense, depending on the jurisdiction, can go outside of those lines. Well, that might be a reason or a means to appeal, imposed by a court not having the jurisdiction of the authority. And that's really all we're going to talk about today. I wish you all well. I hope everyone is safe. I hope everyone is healthy out there. This is Professor Keith Ross. I am signing off. Have a great rest of the day.